SJC-12115, Commonwealth v. Victor, Rosario.
Good morning. May it please the court. My name is Jessica Langsam. I'm sorry, Your Honor.
One second.
Gotta wait for the light.
Thank you, Judge.
All right, you're still Jessica Langsam.
Yes, Your Honor.
Okay.
Good morning. May it please the court. I'm from Middlesex. With me is Assistant District Attorney Thomas O'Reilly, who's also a prosecutor in Middlesex. He was one of the prosecutors on the motion for new trial, as was I. The judge's order allowing the motion for new trial in this case was rooted in a determination that delirium tremens was new and that it cast real doubt on the justice of the conviction, and neither of these is correct. Delirium tremens was not new, and in fact, it was an issue that was well known at the time of the crime in 1982 and at the time of the motion hearing and the trial in 1983. And in fact, this could have been diagnosed in 1982 and 1983 because the information that would give rise to the diagnosis was known to the defendant. The defendant knew about the quantity and the timing of his drinking. And there was testimony by the doctors at the motion to suppress and at trial with respect to how much the defendant drank. Dr. Weiner gave testimony both at the motion to suppress and at the trial that he had gathered information about the defendant's...
It's new because DT is different from psychosis.
Your Honor, that's correct. Delirium tremens is different from psychosis, but it doesn't cast real doubt on the justice of the conviction because the defense at trial and the defendant called a gold standard psychiatrist, Dr. Robert Weiner, who testified that the defendant was psychotic at the time he went through the police interrogation and that because of this psychosis, he was unable to make a voluntary statement to the police.
But aren't we conflating two things, though? I mean, one is, at least I thought where you were starting was that it isn't new in the sense that the gold standard psychiatrist or somebody else could have analyzed these records and communications with the defendant and made that diagnosis. Is that what you're saying?
Yes, Your Honor.
Which is something different than what I think I mean, maybe that's where Justice Hines was, but your answer sort of suggested that, well, because psychosis was presented to the jury, it doesn't matter about the DT. Is that what you're saying?
Well, it's not that it doesn't matter. It's clear that DTs is a different diagnosis than psychosis, but where all of the doctors at the time, and not just the defendant's doctor, but Dr. Kelly, who was the Commonwealth's expert at the motion to suppress and at the trial, and testified in 2014 hearing on the motion for new trial, and all the other doctors, Dr. Schmidt, who did the 18A evaluation at Billerica, Dr. Fine, who did the intake at Bridgewater. There was, and also Dr. Valiz, who conducted an interview with the defendant in Spanish. All of these doctors opined that the defendant was psychotic. Dr. Weiner specifically said that it was this psychosis that rendered him incapable of making a voluntary statement. So, Your Honor, even though these are different psychoses, different diagnoses, where the symptoms and where the result was the same, where the defense was, I couldn't give a voluntary statement because I was psychotic, and where the delirium...
But don't you realize that a jury considering psychosis, which in some respects could be considered subjective, and DT is totally different. I mean, DT is based on some objective facts that the defendant had no alcohol after this fire. So it doesn't really focus on what the doctor said. We're looking at what counsel was supposed to do. And this is what the judge says, that he had all of these experts, so why would he look for something else if everybody is saying it's psychosis?
Well, Your Honor, the case law is very clear that where the information is within the defendant's knowledge, as I said before, the defendant knew how much he drank, and he could have communicated this to his attorney, and he in fact communicated this to the doctors. So it was clear that the defendant was regularly consuming alcohol. So this was information.
Counsel is not a doctor. The lawyer is not trained to know the difference.
Yes, Your Honor. And I know that what Justice Tutman concluded was that the reasonable lawyer wouldn't have looked any further where all the doctors made the diagnosis that the defendant was psychotic and not suffering from delirium tremens. But there was evidence both from Dr. Wiener, who testified that he gathered information about the defendant's history, that the defendant was an alcohol user. The defendant was drinking more than usual the day before the fire. He testified both on the March 10th motion hearing and on the March 23rd at trial. Dr. Veliz testified that he interviewed the defendant in Spanish a number of times. Dr. Veliz was from Guatemala. He was a native Spanish speaker. That the defendant said he drank a bottle of rum on Thursday, then a six-pack of beer, and the defendant told him he had a history of drinking and using drugs. That's the March 23rd transcript at page 580 to page 581. So while it's true that defense counsel John Campbell, who's now deceased, was not a doctor, this was information that was conveyed to the doctors at the time. And this new opinion that the defendant was suffering from delirium tremens, Your Honor, going to trial, even if this new opinion had been presented, it's an opinion of the doctor. So there were opinions of the doctors that the defendant was psychotic. There would be an opinion of the doctor maybe that the defendant was suffering from delirium tremens. But to go back 30 years later from a conviction that's final and where the defense was, my statements were involuntary because I was psychotic. And the defendant himself testified at trial that he had no memory of the interrogation. So the defendant's testimony was consistent with that as well. And the defendant called other witnesses who testified that he was acting crazy, that he lost it, that he seemed out of his mind. So there was substantial evidence that the defendant was psychotic right after the fire and before the police interrogation and then during the police interrogation.
Can I ask you a question about
Yes, Your Honor.
about the fire science? It's raised in the defense brief. And obviously, you don't focus on it because you're appealing that part on the statements that Justice Tutman's decision. On fire science, Judge Tutman credited Lantini and thought it was new evidence, but she said that because the fire arson evidence corroborated the confession, it didn't cast doubt on the conviction. But isn't the standard whether or not the new evidence would have impacted the jury's decision? I thought that was the standard that ought to be applied.
Yes, Your Honor. I know that Justice Tutman took that language from Commonwealth versus Lefebvre. And Commonwealth versus Lefebvre talks about, it was a post-conviction, I think it was a report and expert testimony about why children could testify to sexual acts that they hadn't actually experienced. And what the court says there is, the important point is that Dr. Bruck, that expert in Commonwealth versus Lefebvre, that the proposed testimony was corroborative of evidence available at the time of trial. Her evidence would have simply tended to support the opinion evidence available at the time of the defendant's trial. And I think Justice Tutman concluded that because fire science has made advances since 1983, that wasn't available. It didn't corroborate what the evidence was, but I think Your Honor is correct about the standard. Commonwealth called at the motion for a new trial hearing Mass State Police Sergeant Paul Horgan, who had 20 years experience in the fire and explosion unit, had investigated approximately 1,600 fires in the course of his career. He testified that based on the National Fire Protection Association manual, NFPA 921, that while that didn't exist at the time, that the investigators, particularly Sergeant Coonan, who was attached to the State Fire Marshal's office, conducted a scientific investigation consistent with the principles that are subsequently laid out in NFPA 921.
Right, but that doesn't mean that Lantini et al. Wouldn't have been new evidence,
Yeah,
right?
you're right, and I thought the standard was that the judge has to take that new evidence, Lantini's in the new fire standards, and see, well, if we had this new evidence, how would a jury have evaluated it?
Yes, Judge.
And it may be that you look at the confession, you look at the other evidence, it would have made a difference. I don't know, but I thought that was the analysis.
Just isn't, following up on that, it seems to me that isn't the point, though, that the problem at the first trial was that the confession didn't correspond with the fire science evidence at all, right?
Actually, I'm sorry to interrupt you, Your Honor.
Is that not
Actually,
so?
it did. It did, Your Honor. And in fact, the defendant started, the police had spoken with the defendant in his apartment that afternoon. So the crime occurred Friday morning.
You're right, because yes, I'm sorry.
And it certainly was corroborated by physical evidence that was recovered.
It was corroborated. There were 3 search warrants that were executed on Sunday after the defendant's confession. So the confession ended at 5 o'clock in the morning. The police executed a search warrant in the common cellar at 38 Branch Street, where both Felix Garcia and the defendant had separate apartments. They seized a paint can that had a Miller beer bottle inside. They also seized, the Miller beer bottle. They seized from Felix Garcia's apartment this Red Devil paint remover. So that was corroborated. This was physical evidence that was seized after the defense confession that was corroborated by the evidence that was found.
I'm sorry, I thought there was no accelerant found.
I beg your pardon, Your Honor?
I thought there was no accelerant found.
There was no accelerant found in the wood samples that were taken from the apartment, Your Honor. Yet there was glass that was found in the kitchen, which the FBI determined could have been consistent with the Miller beer bottle.
Right, but could have been consistent also with a beer bottle being left in there and then being destroyed by
Yes.
falling debris or whatever else, I assume, correct?
Correct, it could have been. Yet Sergeant Horgan had testified, too, that based on the manner in which samples were taken at the time, samples were taken in paper bags. Now the methods are different. So samples that might contain trace amounts of a flammable fluid would be preserved in a Tupperware container because there might be just such a minute amount that it wouldn't be lost.
Now, isn't the analysis now different in light of our decision in Commonwealth versus Epps? Don't we now focus on the fundamental issue of whether there's a substantial risk of a miscarriage of justice, and view all of the factors together, the DT issue, the new information about the increasing or about the risk of false confession, as well as the new fire evidence? Don't we need to consider that as a totality and evaluate whether or not the judge abused her discretion in finding a substantial risk of a miscarriage of justice?
Well, and I think that is consistent with Brescia, consistent with the standards set out in Rule 30 as to whether or not justice was done, whether or not there was a substantial risk of miscarriage of justice. And even, Your Honor, I would submit, first of all, the delirium tremens determination is the only determination that the judge made where the judge concluded it was both new and that it cast real doubt in the justice conviction. So the judge did not conclude that, or concluded that the fire science alone, while it was new, did not cast real doubt, nor did this new evidence of coercive interrogation techniques. So at base, if that is not correct, then that was the basis for the court's decision.
But at the end of the day, it seemed to me that she did, I agree with you, the fire science alone, but she did talk about the fire science in combination with the DT.
Yes, Your Honor, and that's envisioning what a different trial would look like if different pieces were taken and replaced. This is very unlike the kind of situation I think Your Honor is referring to, Chief Justice, or the situation presented in Brescia, where you had an individual who, on his second day of testimony, was being cross-examined, had experienced a stroke. The jury wasn't aware of that. It actually could have affected his testimony, or it seemed to have affected his testimony. And the motion judge in that case, who was the trial judge, concluded that a new trial was warranted because under this totality of the circumstances that justice wasn't done in that case. This is very unlike that situation.
Right, but it is closer to Epps, where when you look at what the world looked like in 1982, in terms of the understanding with regard to the risk of false confession, which was perhaps just evolving, but well before the false confessions that triggered an increased understanding, and at an earlier stage of fire examination, which apparently has since been debunked, that looking at it in 2015, I guess, is when the judge decided it, that the judge essentially looks and says, I've got a real concern that there was a miscarriage of justice here, and I think this warrants a new trial.
Well, Your Honor, that's not exactly what how Justice Tutman ruled.
She didn't have the benefit of Epps. I mean, Epps was the first time we had said you can conflate. You don't need to look. Epps basically said, well, it wasn't really ineffective assistance of counsel, and it wasn't really new evidence. But when you combine the two together and you consider whether there's substantial risk, the answer is yes. And it seems as if that is consistent with what is going on here, where the judge is looking at three things together and saying, ultimately, when you look at all of them together, I, the judge, have a substantial concern that justice was not done.
Well, Your Honor, I'd like to, and I think this is why it's important to look at the judge's decision with respect, because after I think it was a 6-day hearing on the motion for new trial, obviously a voluminous record on the motion to suppress and the trial record, and if I may continue, as Your Honor just said, that the arson science has been debunked, that's not what
I didn't say
came out.
debunked, I said advanced. I said certain understandings that were commonly thought to be true or thought perhaps not to be true, which was why certain people say that it's indeterminate now based on what we know now versus what we knew 25 years ago.
Well, that's true, Your Honor, and I just don't want the court to gloss over the fact that the judge concluded that all of the witnesses who testified at the motion for new trial hearing were competent to offer opinions, except that with respect to what John Lentini and Craig Baylor testified, they did not offer an opinion that what happened was or wasn't arson or was and wasn't an accident. Their testimony only impeached the testimony of the investigators at the time, specifically Sergeant Coonan. And as I've said before, in Sergeant Horgan's opinion, Sergeant Coonan followed this investigative method, took a systematic approach, concluded that there were 2 points of origin before Mr. Evans made his statement, and Sergeant Horgan concluded, even applying modern fire science principles, that the fire was incendiary because Mr. Lentini and Mr. Baylor hadn't considered all of the evidence, hadn't considered the witness statements, which included these 3 individuals who saw fires starting at different points: Robert Arthur, who lived across the street, Marie Hinchy, who was on the 3rd floor of the building to the left as you face the building that burned, and Daniela Martinez, who was the woman at the apartment where they went to buy drugs that night. So the Lentini and Baylor didn't consider the witness statements, and Sergeant Horgan, considering that and considering Mr. Evans' testimony, which was that he's walking home at about 1 o'clock, hears a window breaking, looks over, sees a man with his arm raised, who he later identifies as the defendant. And at that time, he doesn't smell smoke, he doesn't see fire, he doesn't hear shouting. So this new this new fire science only really impeached the opinions of the fire investigators at the time. It didn't offer any different conclusion. And modern fire science, that is, in the opinion of Sergeant Horgan, is that he agreed with the investigators' conclusion that these irregular burn patterns in the front hall and in the rear corner of the kitchen, the front hall is where the Commonwealth alleged the defendant threw his Molotov cocktail, and the rear corner of the kitchen is where Felix Garcia threw his, were consistent with the use of an ignitable liquid accelerant. So in other words, going forward, that opinion still stands even in light of the new fire science.
So why did this judge abuse her discretion, which is our standard?
Why did this judge abuse her discretion in allowing the motion?
A judge who obviously is concerned that justice may not have been done, obviously does an exhaustive analysis, 99 pages of carefully reasoned, and you're saying that we are going to find that she abused her discretion. Why should we do that?
Your Honor, because after 30 years where this conviction is final, the defendant has not only had the opportunity, but has raised the voluntariness of the convictions before. The appeals court even said, the voluntariness of the statements, the appeals court even said on the appeal from the order denying the first motion for new trial and the direct appeal, the voluntariness of the confessions was no longer an issue. That, plus where the judge really rooted her decision in this determination that the DTs was new, and it still has to be new, material, credible, and cast real doubt on the justice of conviction. In light of the defense at the time, it simply doesn't do that. And the judge herself concluded that these 2 other factors, the allegedly coercive circumstances of the investigation, which doesn't rise to the level of a De Giambattista type of investigation, or type of, interrogation, and the fire science standing alone didn't do it. So by analyzing each piece of the judge's decision, which was careful, thoughtful, comprehensive, looking at all the factual findings the court made, taking away that DT's piece and looking at these pieces individually, it doesn't cast down the justice of conviction. So for all those reasons, I'd ask this court to reverse that order.
Thank you.
Thank you, Your Honor.
Ms. Kavanaugh?
May it please the court. Lisa Kavanaugh, along with co-counsel Andrea Peterson, on behalf of Victor Rosario, who is present in the courtroom. As Justice Gantz just put it, the only issue before this court is whether the motion judge abused her discretion in finding that justice was not done based on multiple strands of new evidence that implicated both the voluntariness of the confession and also the fire science behind the original determination that this was an arson at all. There's simply no basis to disturb Judge Tutman's carefully constructed and reasoned decision based upon 6 days of evidence, or to find that her decision here was manifestly unjust. And that is because Mr. Rosario's case, as Judge Tutman found, constitutes a virtual perfect storm of injustice, the full magnitude of which was only revealed when Judge Tutman carefully looked at all of the pieces of this equation, all of the different strands of evidence that were used to convict him at trial, and how they held up to the new evidence that was presented over the course of the 6-day hearing.
Can I ask you about the statement? If we had a case before us, not this one, but if there was an NGI case, and the theory at trial was that someone was paranoid schizophrenic, they had a diagnosis, and the gold standard of defense experts that examined this person and found that he was paranoid schizophrenic. It goes to trial, the person's convicted, and then 30 years later, a new gold standard of experts come say, that those first experts were wrong. He's not schizophrenic. He's actually suffering from a depressive disorder that the first experts didn't pick up. Do we grant new trials in those instances?
I think the question is the same in that context as it is here, which is whether the judge it's subject to the same standard. In other words, is it new, and would it have made a real difference to the jury's deliberation? So if the new diagnosis is sufficiently different.
So if we have depressive disorder, it was well known back then, delirium tremors in this case was well known back then, and these experts, the first set of experts, picked whatever diagnosis they came up in good faith. So how is that new going forward 30 years later?
I think the key to the judge's decision here is her analysis of the degree of diligence required of counsel. When she looked at the question of whether delirium was new, obviously the diagnosis of delirium was known at the time, and so what she focused on was correctly what was counsel expected to do. And she made a set of findings related to why the reasons why this diagnosis could have been missed by even competent medical professionals, and then also why, in light of the fact that 5 different experts were telling the counsel that the correct diagnosis was psychosis, why no more was required of him. But critically, the court's analysis of this decision to grant the new trial motion follows along with its analysis of other cases in which judges have found that there wasn't that there wasn't sufficient diligence. In other words, the key is that the review of the judge's detailed findings on diligence are deserving of this court's. I apologize, I'm losing my my words, that they're entitled to deference. The judge made a set of findings related to diligence, and that it will always be bound by the facts of the case. And so the key to the judge's analysis here, as it would be in any case involving a changed diagnosis, is how different is it from the diagnosis at trial, as well as could it have been determined through the exercise of reasonable diligence.
So on the how different is it from the diagnosis at trial? Both of the diagnoses obviously go to the point of that the confession wasn't voluntary, and going beyond that, false. So how do we weigh whether it makes a difference between the reason is psychosis versus the reason is delirium tremens?
I think what this court needs to do is to look at how the judge approached that question. And what she did was she approached it by noting that it's a profoundly different conclusion, that we're not talking about mental illness, we're talking about a medical condition. And that medical condition rendered, according to Dr. Edersheim and Joseph, rendered him suggestible, confused and disoriented, and lacking the capacity to make a voluntary statement throughout the interrogation, which the court noted is fundamentally different from Dr. Weiner's opinion. At the course of this supposedly gold standard opinion, he acknowledges on cross-examination by the prosecutor, Dr. Weiner acknowledges that psychotic people can make rational statements, that it's not an all or nothing thing. That's a critical distinction that the judge found in looking at how the explanation offered by Dr. Edersheim and Dr. Joseph differs from what was presented at trial. And she also notes that the diagnosis of delirium has a fundamentally different fit with the symptoms that were observed by multiple witnesses throughout the period of time leading up to the interrogation, during the interrogation, and for many days thereafter.
And then,
so
and
it's
then
that
the fact
fit.
it also fits with the behavior later.
That's right, that it offers an explanation that encompasses all of the features of what was observed about Mr. Rosario, not just pieces of it. And critically, the judge emphasized that it explains why he may have appeared lucid during periods of time in the interrogation, which of course at trial was a fundamental problem for the defense, because that was an area where the prosecution was able to contend he collected himself. So this new medical explanation offers a fundamentally different way of understanding what was outwardly observable about Mr. Rosario during the interrogation. And so this court, in looking at Judge Tutman's findings on those points, need only ask, did she abuse her discretion in finding that the combination of this different fit, this different diagnosis, and the different factual basis for the opinion, whether that would have made a real difference to the jury and to the motion judge in determining whether the statement was admissible in the first instance. I think the other key issue to keep in mind, and this is something that Justice Gans touched on, is that the way in which this court approaches cases involving changed forensic science, which unquestionably is the case here. We have a completely different world with regard to how we understand fire science from 1982 to the present. The Commonwealth does not contest that. We also have a completely different world with respect to how we understand the effect of interrogation techniques on suspects and the possibility that an innocent person could falsely confess to a crime that they did not commit.
And you disagree with Judge Tutman's conclusion on fire science, correct?
We did not file a cross appeal. We did not have an adverse ruling, but certainly I think that the amicus brief in particular raises some very compelling points in favor of finding that, that the court's decision could be upheld, that this court could find that even the fire science alone, under the Epps decision, which the court did not have the benefit of, would constitute sufficient grounds. This court doesn't need to reach the question of whether fire science alone would be sufficient, but certainly the amicus brief makes some compelling points about why the fire science on its own, compared to the other evidence, might be sufficient. But it's true that Judge Tutman did not make that finding. She in essence, intuited what I think this court articulated in the Brescia case and then in Epps, the idea that at its core, what Rule 30 asks was justice done, and that she approached that using the blueprint that was laid out in Commonwealth versus Grace, applying the correct legal standard, which the Commonwealth does not dispute she did, making a set of very well-founded factual determinations, which the Commonwealth also does not dispute she made. In fact, the Commonwealth focuses on the delirium, but the judge made findings that the fire science was new, that the Commonwealth does not dispute. The Commonwealth also concedes that the delirium diagnosis, that there was credible evidence from which a jury or a motion judge could determine that Mr. Rosario was suffering from delirium tremens. And they concede that there were facts established in the hearing from which a jury could reasonably conclude that the police engaged in a number of interrogation tactics that we now know, through the benefit of social science research, can cause false confessions.
And now, on the fire science, and you'll help me on this, did Mr. Lantini say that rule out the use of an accelerant? Because my memory of his testimony is he says that, well, police for years, wrongly, said it was a poor pattern based on, but what we know now is flashover, an artifact from flashover can give appearance of a pour pattern, and that's not taken into account. It doesn't rule out that it could be a pour pattern, but it also says it's inconclusive because it could be flashover artifacts. Is that what, was that
That's
his
correct.
testimony?
Both John Lantini and Craig Byler opined that the only possible opinion that is supported by the evidence in the case is that this was an indeterminate fire.
Okay.
They also made a critical finding, however, that a component of Mr. Rosario's statement, the final confession, was that he threw a Molotov cocktail into the front hallway, and that was the cause of the fire in that location. And both John Lantini and Craig Byler concluded that the physical evidence at the fire scene does not support that a Molotov cocktail could have been a competent ignition source in that room. And that is a very critical finding. They didn't reach the question of whether a Molotov cocktail could have been at all involved.
Did Lantini take into account the defendant's statement, which I know you obviously contest, but did he take into account the statement plus the physical evidence that was gathered from the search warrant executions?
Absolutely. Both of the experts were fully aware of all of the evidence that had been collected, including the evidence collected subject to the search warrants. And they found significant that there was absolutely no lab confirmation of the presence of an accelerant. And in a fire that was allegedly set by 3 separate Molotov cocktails, there were no remnants in any of the 3 locations in which those items had allegedly been thrown. So they focused on, and then with respect to the front hallway, where Mr. Rosario allegedly threw a Molotov cocktail, they made a set of additional findings that are significant both for what they say about the fire science presented at trial, and also because, as Judge Tutman found, they would likely have influenced how the jury understood the fit between the physical evidence and Mr. Rosario's confession. And as this court recognized in Di Giambattista, the lack of fit between the facts of a confession and the physical evidence is an important red flag for questioning whether confession may be false and unreliable. So the court looks at the interaction of all of these different pieces of evidence properly, and properly concludes that it's not, even if in isolation the fire science, in her opinion, would not have been sufficient, that you don't look at it in isolation. That's not the way this court has directed judges to examine evidence presented in this context, and it shouldn't be. We now have a world in which we know that flawed forensic evidence contributes to a significant number of wrongful convictions. And to suggest that the court should look at the changes in forensic science in a vacuum without examining how they influence all of the other pieces of evidence presented to the jury runs contrary to the wisdom of history that we now have the benefit of. This court recognized that in the Epps decision. And certainly I think that Epps articulates yet another way in which Judge Tutman's reasoning and decision should be upheld, and that this court should find that she did not abuse her discretion here.
Can you address the results of the search of the basement and the discovery of the, Black Devil or something, the Black Devil accelerant?
Absolutely. So
Red Devil.
there were two findings, essentially. There was a gasoline tank found in the basement, and there was evidence at the trial from the landlord of the building indicating that this was a kind of can that he kept in the basement. There was absolutely no evidence that gasoline was used in the fire. And with respect to the Red Devil paint thinner can, which was found in Felix Garcia's apartment, I think this court, although Judge Tutman didn't focus on this, I think this court can note that there was no mention in the third statement signed by Mr. Rosario of a Red Devil paint thinner. Sort of after the fact, it appears that the police attempted to make sense of the repeated statements by Mr. Rosario throughout the days leading up to and since the interrogation referencing the devil. And they came to a particular set of beliefs about the connection between his statements about the devil and this can. But in fact, that was not present in the statement that he signed. That wasn't part of the confession that was attributed to him. And most importantly, as both of the post-conviction arson experts emphasized, there simply was no physical evidence found in the fire scene that in any way corroborated the use of an accelerant. And every single piece of evidence that was relied upon by the fire investigators to conclude that this had more than one point of origin, that it was an unconnected fire, and that accelerant was used, every single one of those has been discredited in the sense that it can now be explained by a ventilation-controlled fire that was fully involved, as this fire clearly was. And so truly everything about this case, while the individual facts may be complicated, what is very simple and what this court should find is that Justice Tutman was correct in her determination that justice was not done, and there was no manifest injustice in her conclusion that Mr. Rosario was entitled to a new trial.
Did the police look at an alternative source for the fire? That being some type of accidental, electrical, or any other?
That was another important component of Dr. Byler and Dr. Lentini's critique of what occurred here, because it was very evident from the record that when the fire investigators first approached the building, they had already in their minds decided that this was an arson, based on another set of assumptions which turned out to be inaccurate regarding the fast.
There was a heater or something, they didn't inspect that?
That's right. And what Dr. Byler in particular emphasized is that because the investigators incorrectly defined the point of origin too narrowly, focusing only on one small region in the kitchen and one small region in the front hallway, that they failed to consider the possibility of accidental sources in any other location on the first floor, which meant that they did not look at the space heater that was in the living room, a room that was completely destroyed by the fire, and they did not consider electrical sources of the fire in any location other than those two small places. And so that failure to collect the data was another way in which the fire investigation was influenced by a set of incorrect assumptions about what could be said based on where the worst damage was observed. And that once they made that initial incorrect determination, it infected every other aspect of their fire scene investigation and their interrogation of Mr. Rosario.
And the fire occurred on March 5th. Was there evidence as to the weather that night, as to how cold it was?
I don't recall that there was any evidence one way or the other.
Okay, thank you.
Thank you.